Hello, my name is Jonathan Edwards. I'm a barrister in private practice at Radcliffe Chambers, and today I'm going to be speaking about disputes and testamentary capacity, and with a particular focus on what we can learn from the recent case law. Along the way, we'll be recapping the basic principles, some of which are not at all recent, but we're going to be focusing mainly on how the courts weigh the evidence, the different kinds of evidence you have in these cases, and factor them into an overall conclusion. And for that part, we're going to be emphasising in particular on what the recent cases show us about how that works in practice. I would say also there are lots of reported cases involving testamentary capacity. I'm going to focus mainly, although not entirely, on cases where the litigants on both sides were represented. There are a fair number of decisions where at least one party was acting as litigant in person or just didn't participate at all. And in my view, those are a lot less telling about how the courts deal with properly contested cases. I tend to find that although the law in this area is not something that litigants in person have particular difficulty with, because although there's lots of nuance to it, the general thrust is understandable. They are quite substantial cases to litigate. And in my experience, litigants in person are not good at focusing on what is the relevant evidence, collating it, and putting it before the court in accordance with the procedural rules. So I rather suspect that quite often you don't get a real feel for the true strength of a case. And in fact, there's one recent case called Ray and Ray, which I think is a very telling example of that, where litigants in person were challenging a will. They lost the trial. They appealed it twice over, and eventually they did manage to get a retrial. And then at the retrial, they were represented. They've been represented on appeal also. And that retrial resulted in the opposite outcome. And I think that's quite a good example of how presentation of the case can make all the difference.